Sunday on the Attorney's Criminal Law.
Do you know what to do if you've been arrested? We've got some answers.
Call, text, email, then join me along with the experts from Hollis Wright Sunday after Alabama's 13 News at 10.
Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the Attorneys. Appreciate you spending your Sunday evening with us. For the next half hour, our topic of conversation is going to be criminal law, and we would love to have you be a part of the conversation. We have the panel of experts. You provide the questions. That's the way the show works. We'll pass them right along to our experts who are here tonight. You can call, text, email. There are attorneys standing by right now to answer those emails and texts and also take those calls. So get in touch with us. Would love to have you be a part of the conversation. The topic of conversation is criminal law. Leading the conversation, as he often does, Josh Wright of the firm Hollis Wright. Good to see you, sir.
Good to see you too. Hope you had a great week.
Good indeed.
You know, we do shows that are relevant, and unfortunately, those in our community sometimes will have run-ins with law enforcement.
Right.
And whether they're state cases, federal cases, whatever it may be, we try and bring experts on that can help answer those questions. And Josh Jones has his own firm here in town. He's an expert in this area. This is primarily what he does. Probably 80 to 90% of what he does is criminal law. So we're excited to have you on today, and he's out on 280 and got a great firm and just blowing and going, doing a good job in this type of law. Tell us a little bit about your background, because you've got a prosecutorial background too that started you on the prosecution side and then
Yes.
you've worked your way over to the criminal side, I guess.
Yes, and I appreciate it. Thank you for inviting me on.
Yep.
I'm a former prosecutor. I spent 5 years at the DA's office in Montgomery, not Birmingham, and enjoyed my time there. Got a lot of experience, a lot of trial experience. Tried at least a dozen jury trials. Started my own practice. I want to be back in Birmingham, and I've been open for about 2.5 years now. And like you said, primarily criminal defense, and doing a good job at it. And I'm glad to be working for myself, and things are going well.
That's awesome. You think that being a prosecutor for a period of time has helped you be a better criminal defense lawyer?
Definitely, because for a number of reasons, but primarily because you get that experience. At the DA's office, they just put you right in there. There are thousands upon thousands of cases that the DA's office handle, so they can just put you right in there. If you lose a trial, you lose a trial. There's another one next week. But also you get comfortable being in the courtroom. You get comfortable being in front of the judge, talking to people, talking to other attorneys. So it's been invaluable experience, and I definitely owe my success partly, in fact, to being a former prosecutor.
Now, our firm does civil-related work. When we have criminal issues, we come to guys like you.
Right.
The standards in a civil case and a criminal case are totally different, aren't they?
Yes, definitely.
And can you just kind of give us a lay of the land of what the standards are, kind of the burden of proof on the criminal side, so people get kind of an idea of how difficult it is sometimes to get a conviction for somebody that's committed a wrongful crime?
Sure. And in the criminal world, we're dealing with a standard that's beyond a reasonable doubt. Now, it doesn't mean it's beyond all doubt. It doesn't mean it has to be to 100% certainty, but it is the highest standard in the law, and that is beyond a reasonable doubt. Attorneys don't usually like to put a percentage on what that means, because people get it in their mind that, okay, then that's the percentage it is. There is no real percentage of it, but it's beyond a reasonable doubt, which is the highest burden in the law. You have to be able to attach a reason that you have a doubt that this person is not guilty of the crime.
Gotcha. And I would suspect that is kind of your role as a criminal defense lawyer when you do try cases. Your goal is to find some reasonable doubt that allows that individual not to be convicted of the crime.
Sure, definitely. And as a criminal defense attorney, if you get in front of a jury, you want to repeatedly talk about that high standard, that high burden that the jury has, or the prosecution has to prove that is beyond a reasonable doubt. Whereas if you're a prosecutor, you don't really talk about that quite as much, because it is such a high burden.
You know, David, and we've talked about this on other shows. Of course, I'm not a criminal lawyer, I'm a civil lawyer, but I learned back in law school, and it's always made sense to me that when you have such a high standard, it's because you're taking away somebody's civil liberties. You're taking away their right to be in society like the rest of us, and so it's a very high standard. And the goal is that you probably are going to have some people that did some bad stuff that get off, but the goal is that it's a high enough standard that the innocent person is not wrongfully convicted. And that has always resonated with me. It's always made sense as to just how high that standard is, that bar is, in order to criminally convict people in our community. We want to make sure that the innocent person is not being wrongfully convicted.
And help us understand how this works. Let's kind of go back to the beginning and understanding criminal law. If you get arrested, kind of talk us through those first steps. You've been arrested. What's the next? What are the next steps that need to be taken there?
Sure, and that's a great question, and that's probably the most common question I get. The main mistake I see, or I see defendants make once they get arrested, is they start talking. You know, I think it's human nature to feel like you have to explain yourself. You know, we've all probably seen the TV shows where they've got a camera in the room. You see the defendant, you see the officers coming in. And, you know, me at home, I'm thinking, no, don't do it, don't start talking, just ask for your attorney. But for some reason, they very rarely do that. And I think that's the most important thing that they should do. You have a constitutional right to remain silent. You don't have to talk to the police officer who's investigating your case if you've been charged with a crime. I would say that the most important thing to do is exercise your right to remain silent. You do not have to explain to the police officer your side of the story. The other main thing I would say to do is hire a competent attorney. Hire an attorney that specializes in criminal law. And Josh, I've heard you say this before on previous shows. Different attorneys do different things. You have plaintiff's attorneys, you have defense attorneys. I specialize in criminal law, so that is what I'm familiar with and comfortable doing. So hire a competent attorney that specializes in the area of law in which your situation arises.
That takes us to a question that we've got about the need for an attorney. Do I necessarily need an attorney for my criminal case?
I would say yes, definitely. A lot of people think that they can go into the courtroom, negotiate their own case, talk to the judge, talk to the prosecutor, and get their case resolved to their benefit, but that's just usually not real life. Believe me, when you walk into a courtroom, it's an intimidating place. You have a judge on the bench, you have a prosecutor, you have several police officers there. You will wish you had an attorney once you step into the courtroom, and I've seen that happen more than once, where somebody gets into the courtroom, doesn't feel comfortable, and has to ask for a continuance because they want an attorney at that point. So hiring an attorney is definitely the way to go. Sometimes I make the analogy that if you're not a doctor, you wouldn't perform surgery upon yourself, so why would you try to handle your own criminal case? So definitely hire an attorney, at least speak to an attorney before you go into the courtroom to make yourself feel more comfortable.
Go back to your constitutional rights for a minute. As I've always wondered this, you have the right to remain silent. We've heard of Miranda, for example.
Correct.
Remaining silent doesn't mean that you're guilty, does it?
No, it does not.
It's just exercising the right that you have to go get a lawyer to help lead, guide, and direct you through the process.
Correct.
And I think that's kind of an important point, because I bet why people talk most of the time is because of the fact that they think that people are going to think they're guilty if they don't tell their side of the story. But exercising your constitutional right to go get a lawyer doesn't necessarily mean that.
No, it definitely does not, and you're probably right. They do feel the need to talk about it. But the prosecution and the state is not even allowed to use that evidence against you in front of a jury that you exercise your right to remain silent. They can't even say anything about it because you have a constitutional right to remain silent. But, you know, like we alluded to, I think it's the need to explain your situation and the need to prove your innocence. But, you know, that's just not something that you feel like you should have to do.
Time for our first break of the evening. Got a question here about the differences between a misdemeanor and a felony. We'll get to that. Those sort of the questions that we love to pass along to our panel of experts. So join the conversation. Call, text, email. Get those to us, and we'll be sure and pass them along. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Now, your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family, or simply contact us by going to alabamas13.com and click on the Attorneys link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
A, B, and C. Different types of felonies there. Welcome back into The Attorneys. Those firm facts do a great job of just kind of pointing out some overviews on some things, but to dig deeper, we'll have to take the questions to our panel of experts. So join the conversation. If you have a question, we'd love to pass it along to our guest tonight. A question we have here: what is the difference between a misdemeanor and a felony?
Sure, and it sounds like a simple question, but you know, I could probably give a variety of different reasons or the different ways a misdemeanor and a felony. But the main thing is a felony is a more serious charge. Like the screen said, there's A, B, and C felonies, and there's A, B, and C misdemeanors. A felony is anything that is punishable by a year and a day or more in prison, whereas a misdemeanor is anything less than a year. You know, you can give a variety of examples. The felonies are the more serious charges: the burglaries, the robberies, the rapes, the murders, things like that, whereas the misdemeanors are the minor offenses, some of your traffic violations, your harassment, your calls. The lesser of the two are the misdemeanors.
Right. You've got an opportunity, if you've got counsel, even on the felony side and the misdemeanor side, to try and police some of those cases down, do you not?
Correct, correct. And that's a lot of times is what a criminal defense attorney will do for you. It's just not practical to get every case dismissed. Everybody wants their case dismissed for one reason or another, but a lot of times what a criminal defense attorney will do is hopefully get your case reduced from a felony to a misdemeanor, which is a much less serious charge. So that happens a lot, and those are plea negotiations in which your attorney would do for you.
You know, on the civil side, I attend a lot of seminars about how to be a better lawyer in certain areas, and a lot of the stuff we attend is how to get evidence in front of a jury in such a way that it paints a great picture and paints a story to the jury. I know the same thing is applicable on your side too. Issues that come up: fingerprints, DNA evidence. Do you have to have those things in order to convict somebody, or can you be convicted with circumstantial evidence? I mean, how to kind of explain that process?
Sure. The short answer is no, definitely not. You do not have to have DNA evidence. You do not have to have fingerprint evidence. And that's one of the biggest misconceptions as far as the criminal law goes. I know other attorneys and I have talked about it. It's kind of like the CSI effect. You see these TV shows on, and the jury and people expect to have all these forensic evidence, the infrared lights and all the detectors and gadgets that you see on TV, and that's just not true. You don't have to have forensic evidence in order to get a conviction. And oftentimes they do not have forensic evidence or DNA evidence. There's only a small percentage of cases that actually have that type of evidence. So the answer is no, you do not have to have that type of evidence in order to be convicted of your crime.
Talk to me a little bit about DUIs. I know that the DUI penalties went up in the last several years with some changes at the legislature. Is that a pretty common issue that you're dealing with people coming in that they've been through circumstance where they are arrested for drunk driving or arrested for driving a boat while intoxicated?
Yes, yes. DUIs and BUIs, which is boating under the influence, is a very common crime. A lot of people get arrested for that, especially during the holidays. So I get a good many calls about DUIs and BUIs. It's a very serious charge, although at your first offense it's just a misdemeanor. But it's actually more than that. It really looks bad on your record. Employers or potential employers will see a DUI on your record, and definitely it puts you in an unfavorable light. So
DUI is a good example, David, of how a lot of times criminal and civil law intertwine with one another. My law firm does a lot of what's called dram shop or liquor liability-based work, where a drunk driver leaves an establishment intoxicated, hits somebody and causes significant injury. Those accidents generally are not minor injuries. Those are generally significant injuries because of speed and vehicles and whatnot. And a lot of times what will happen in those cases is there will be a pending criminal investigation or a criminal case ongoing related to the underlying DUI. And at the same time, we have a civil claim against that same individual and against the entity that may have provided alcohol to that individual. If they provided too much alcohol, they'd be named. And those two things work with one another. And to get a criminal conviction of a DUI oftentimes will actually help the civil case. But a lot of times what will happen is, and I know Josh knows, being a former prosecutor, the civil lawyer will agree to work with the prosecutor to sit back and wait, to not get any evidence that's going to damage that DUI conviction, and allow the prosecutor to do his job to get the conviction or plead the issue out. And then the civil case will move forward. And I know you're on the other side now, but I know as a prosecutor that's something you dealt with probably on a weekly basis for sure.
Definitely, definitely.
Real quick, before we go to this break, another question we have. I wasn't read my Miranda warnings. You all were talking about that earlier. Can my case be thrown out?
I would say generally not. Just because a police officer doesn't read someone their Miranda warnings is not enough to get your case thrown out. It can be an issue. It can especially be an issue if they're trying to use a statement that you said after you were arrested and bring that into court. That's the main reason the Miranda warnings were put in place, so to tell you that you have the right to remain silent. So generally when that would happen or come up is at a trial or maybe plea negotiations in which a defendant might have said something they didn't say but weren't read their Miranda warnings. Usually Miranda warnings are either taped or audio, something inside the police station, and that's where they're usually done, and that's when a statement is usually taped.
Okay. All right. Time for our second and final break of the evening. As we head to break, I want to remind you how you can get in touch with us. You can call, text, email. Also, attorneys are standing by right now to take your calls, texts, and emails. Hard to beat that deal right there. So get in touch with them. They're standing by to speak with you. You can also find the firm on Facebook. Just search the term Hollis Wright, and on Twitter, it's Hollis_Wright. Other great resources for you. Stay tuned. The final segment of The Attorneys coming right up.
I'm Josh Firth with the law firm of Hollis Wright. It's easy to take safety at home or at work for granted, but crime can happen anywhere. That's why for this week's Legal 411, we're answering the question, is your employer liable if you are a victim of crime at work? Generally in Alabama, employers cannot be held liable for the criminal acts of a third party, including physical assaults, robberies, shootings, burglaries, or sexual assaults. This rule is to protect employers from being blamed for acts that they couldn't predict would happen. However, there are two major exceptions to this rule. One, if your employer knew or had reason to know that the criminal act was likely to occur, or two, a special relationship exists between your employer and the criminal. For example, if you work in an area of town where crimes frequently occur at your job and your employer has not taken steps to make sure that your work area is kept safe, the employer may be liable if a crime happens to you. Or if the person who commits the crime is a coworker that your boss knew had a criminal background, your employer could also be held liable. Our advice to you is to be diligent. Take measures to be safe. Check your surroundings. Keep your vehicle locked at all times. Have someone walk you to the car if you leave the office late. Even check with the police department to learn if you work in a high crime area. If you do, check with your employer to see what measures they are taking to keep you safe. Communicating with your employer is generally the best way to make sure you are on the same page with them. Please remember, your call, email, or text to the attorneys is always free. All of us at Hollis Wright want to help answer the questions you face on real issues every day. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thank you for watching The Attorneys on Alabama's 13.
Welcome back into our final segment of The Attorneys. A few minutes remaining, but time enough for you to get your questions to us. Call, text, email to join the conversation. Would love to have you be a part of the conversation.
You know, we were talking off camera a little bit about the youthful offender process. Can you explain that? Because I know there are moms and dads out there who have children who have gotten themselves in trouble that are under 21, under the legal age, and there may be some help for them through certain processes in the criminal context. Can you just kind of explain a little bit about that?
Sure. Youthful offender is for anyone that is 21 or younger at the time of the offense. They are at least eligible for youthful offender. One misconception I can just say right off the bat is just because you've been granted youthful offender one time does not mean you can't get it again. You can get it as many times as the judge will allow it. But it's very important if you're 21 or under at the time of the offense that you at least ask your attorney to consider for youthful offender and go in front of the judge for a youthful offender determination. If you're granted youthful offender, that means it will seal your record if you're convicted. You're actually not convicted of the crime anymore, you're convicted of violating the youthful offender statute, which is a little bit different. So it's important if you're, like I said, 21 or under at the time, to at least ask for a youthful offender determination that you might can get it. You might not, it's up to the judge, but if you do, it's very helpful.
We've gotten a question before on this show when we talked about criminal issues of my job application is requesting information about my criminal history. I want to ask you a twofold question. One relates to what do you do generally, and the other is if you have been convicted of a youthful offender, is there any advice that you'd provide as to whether or not they need to disclose that too? Because I know they weren't actually convicted of a crime, they were convicted of violating the youthful offender statute, but just wanted your thoughts on that.
Sure, and I get those calls oftentimes. The main thing I would say is my general rule would be, read the question carefully. What is the question actually asking you? Some questions ask about convictions, some questions ask about arrest, and those two are different things. Yeah. So you actually have to read the question and make sure that you answer it in the way that it asks. My other thing I would say be honest. A lot of times an employer will do their own background check, and so they already know what they're looking at or what convictions you have. So it's important that you be honest. I've had a client recently that called in and explained her situation to me, and she did have some stuff on her criminal history, but I told her to be honest about it. She was honest about it, and sure enough, she got the job. The employer was okay with what her criminal background was. It wasn't that bad. As far as the youthful offender goes, like I said, read the question carefully. If it says conviction, then a youthful offender would not qualify as a conviction. But if it asks about an arrest, you still would have been arrested, so you would have to answer yes on that.
Another question that we get a lot relates to domestic violence. Somebody will initially swear out a complaint or a warrant for someone's arrest related to domestic violence. Then they decide they've reconciled and they don't want to prosecute anymore. That may not necessarily stop the prosecution, does it?
No, it does not, and that happens a lot, especially in domestic violence situations where you have a boyfriend, a girlfriend, or a husband and a wife situation where maybe they're drinking, maybe somebody gets mad at somebody else, they call the police, charges are filed, and then 2 or 3 months later when the case comes to court, they're back together and they don't want these charges to go forward. I think the biggest misconception as far as domestic violence situations go is that victims, the victim of the crime, thinks that they can go into court and ask the prosecutor or the judge to dismiss the charge, and they have to do that. That's just not true. Once the charges have been filed, the prosecutor is the one in charge of the case. Now, I'm not saying the case can't be dismissed or will not be dismissed, but it won't be dismissed just because you ask for it to be dismissed. A lot of times people think that they can go in and say, I want it dropped, and it has to be dropped. But the prosecutor has to agree to dismiss the charge.
Tell us the difference between a public defender and a private attorney.
Sure. Well, a public defender is someone that's appointed to your case. In Jefferson County, we have a new public defender's office that's just been instituted. They handle a large volume of cases, whereas a private attorney someone that you would hire, whether they work for himself or herself or work for a firm. It's somebody that you would hire as your own attorney.
Some good questions we got from our viewers tonight, but just less than 2 minutes remaining. So from you guys, a final thought from you tonight for our viewers.
Sure. I think that the final thought should be talk to an attorney, a criminal attorney that specializes in that type of law, that has several years of experience, that has courtroom experience, has tried some cases. Like I said at the beginning of the show, everybody thinks that they can handle their own case, but it's just usually not a good idea. Talk to an attorney, hire somebody that you feel comfortable with and that you can trust, and don't go into courtroom alone.
Josh?
Yeah, I think that is a great ending point. I think the goal here is, kind of the goal of our show is, we may not be able to answer every question on every legal topic, but we're going to get you in touch with somebody that can. Right. Josh is a great example of filling a gap for something our law firm does not do. We do not do criminal work. But we get people in touch with guys like Josh because he's experienced, he has been on the prosecutorial side, he's been on the criminal defense side, and he just understands the law. And I think the biggest mistake that you can make is thinking that just because you have committed a crime that there's nobody there to help you. You're on your own. You need to get with somebody that can walk you through the process and lead, guide, and direct you through the process. Josh is a great example of that, and it's why we push people to him to answer questions for sure.
Well, Josh and Josh,
yep.
Appreciate you being with us. Appreciate you being with us as well here on The Attorneys. We're going to be back next week. In the meantime, the firm of Hollis Wright still able to answer your questions. You can call, text, email. They'll get back with you. Also find them on Facebook as well as Twitter. We'll look for you next Sunday night right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis Wright.